Hi everyone, it's Professor Beery here. I'm going to put together a series of videos and materials that you can use in studying for the Florida bar exam coming up in October. Uh, the bar examiners have announced what topics are going to be tested on the essays, and one of those topics is federal constitutional law. So you need to be ready for that. So we thought we'd take this opportunity to make sure that you are. Okay. I'm going to talk about a number of different substantive areas. I've looked, Dean Matthews and Professor Marin have been kind enough to equip me with past questions and sample answers. And I have reviewed many of those to try to get a sense, not only from the Florida bar exam, past Florida bar exams, but also past MEE questions. To get a sense of what are the favorite topics for bar examiners to go after when they're drafting essay questions about federal constitutional law. It's the Florida bar exam again that I'm talking about here. So one would think that the emphasis there would be on constitutional issues that more relate to the state rather than the federal level of government. In other words, if you're studying the Commerce Clause, right, you would think that you'd be more likely to be tested on dormant commerce because, right, dormant Commerce Clause applies to states. Dormant commerce principles apply to states rather than the federal government. However, I have noted in looking at Florida bar exam questions, and one in particular, the bar examiners had a member of Congress from Florida, but a member of the federal Congress from Florida, coming up with some proposal and proposing it in the U.S. House, and the question went on from there. But it turned into then the fact that the member of Congress was from Florida was really irrelevant, completely irrelevant to the answer. And what they did was use that to trigger a federal constitutional analysis regarding the power of the federal government. So substantively, we're going to have to talk about not only issues that more relate to the state or more typically apply to the state, but also federal power as well. I want to make sure we cover all those bases. Now, before we get into substantive coverage of substantive principles, there are two procedural issues I want to talk to you about in this video. One is standing, and the other is the 11th Amendment. There are certain things as we go through these videos and materials that I'm going to point out that you should probably check in your head for almost any constitutional law question. And these two fit that bill. Any time that you see a common law fact pattern, you have got to check for standing. And we'll talk in a minute about how to spot these issues. You also want to be on the lookout that bar examiners seem to be quite fond of testing the 11th Amendment, right? 11th Amendment immunity of states from suit in federal court. So let's talk about that. Number one. Again, if I'm you, I'm going in there, and my mental checklist will include checking for standing. Now, the most likely way that you're going to be tested on standing doctrine on the bar exam would actually be not the hurt feelings stuff that we talked about in Con Law 1. You might recall the case Allen versus Wright about stigmatic harm. Bar examiners, it looks like, and Professor Hardwick, of course, teaches us this, prefer more concrete ways to test these principles. So the most common way I've noted that this issue seems to come up would be the issue of, the combination of an issue of standing and ripeness. In other words, an injury that has not happened yet, that is speculative or conjectural. So let's talk about that. Let me give you an example. A fact pattern in one of the questions I looked at where I believe it was a state suing to stop Congress, a congressional enactment. But here's the problem. The state was suing to challenge a law that was still pending in Congress. Congress had not yet enacted the law. So there's your typical type of problem here. Look for the fact pattern. Look for a fact pattern where there's legislation in committee, there's legislation pending in front of the Congress, right? There's some kind of proposal that's been proposed by some government actor, but it hasn't been implemented yet. That is your classic fact pattern that would trigger a standing analysis. And you would come at this two ways. So we've talked about this in common law. Number one is to go through the elements of standing, and the other is to talk specifically and explicitly about ripeness. The elements of standing, again, are injury in fact, which means an injury that is not speculative or conjectural, but concrete and palpable. Must be caused by the government you're challenging, right? Whoever the challenger is challenging has to be the one who caused. That's element number two. And number three, it has to be redressable by a court. Those are the elements of standing. One of the goals, I should have said this at the beginning, one of the goals of these videos is going to be to paint with very broad strokes. What we're concerned about here is don't miss top level issues. And I've noted in a lot of the answers that are credited, the analysis can be quite general. As long as you hit it looks like as long as you hit some key points and don't miss top level issues, it looks like bar examiners or graders are quite liberal in awarding credit for that. So make sure you spot the issue, right? If there's something hasn't happened yet, you would spot the issue. You would say this is a standing problem. You would go through the three elements of standing and quickly apply them. And when the problem is that the injury has not yet happened, you would then say ripeness, ripeness, ripeness. A case has to be ready for adjudication, right? That's the magic language you want to use. Keep in mind also that on the other end of the spectrum, and this could easily be tested as well, would be a situation where there's nothing a court can any longer do about, right, the injury. And that would be something that goes to element 3 of standing, redressability, and also that would trigger a conversation about mootness. Once there's nothing a court can do about it anymore, a case is moot. There is no longer a live controversy. So that's one of the procedural things that you have to have on your mental checklist. It's often tested. Number two, make sure you're ready, like I said, for an 11th Amendment question. They seem quite fond of that. The 11th Amendment bars a suit in federal court by a citizen against a state by name. Now, be careful. On bar exam questions, they tend to say state A. If this is so easy to miss, don't miss it. They'll say party X sues the governor of state A and state A in federal court. Okay, so the reason this can be hard to miss is they're not naming a state. When you're looking for an 11th Amendment problem, you're looking for a party suing a state by name in federal court. And they're not going to name an actual state, right? Florida or Michigan or New York or whatever the case may be. They're going to say state A. You have to spot that. If the fact pattern says that the party is suing state A in federal court, boom, you have an 11th Amendment problem. As you recall, suing the governor, right, of the state and asking for injunctive relief is not a problem. The problem would be suing the state by name and or suing for damages that would come mostly out of the state treasury. Those would be 11th Amendment problems. Now, I've seen a number of questions where they were testing abrogation, okay? And that is the most complicated part of 11th Amendment jurisprudence. So you want to look for that. When Congress takes away, that abrogates, right, takes away state 11th Amendment immunity, you want to check whether Congress is exercising its power under Section 5 of the 14th Amendment. In other words, enforcing equal protection principles against the states. For our purposes, I think we should stick to that simple principle. Okay, if Congress is trying to exercise its power under some other part of the Constitution, like the Commerce Clause, that's not going to fly as far as abrogation. When Congress wants to take away a state's immunity under the 11th Amendment, which it can under the 14th, it has to be acting pursuant to Section 5 of the 14th Amendment, no other power, right, in an effort to enforce equal protection principles. So watch out. Injury hasn't happened yet. That's an easy little fact to throw in there, and it's pretty common. And watch out also, that would be a standing problem. And watch out also for a person suing state A, okay, in federal court. That would mean you have to go through your 11th, at least spot the 11th Amendment problem, do the general rules. You can't sue a state by name in federal court. What you're supposed to do to get around the 11th Amendment is sue a state actor and ask for a prospective injunctive relief. So hopefully that's a helpful start here. We'll get into more substance in the next couple of videos, but I want to get one up fast. As you build your mental checklist for how you're going to tackle the federal constitutional law question that you know is coming on the next Florida bar exam in October. Till I see you again, stay well and stay safe.